Your Honour, my client, Johnny Wishbone, is a Torres Strait Islander juvenile born on the 26th of June 2000. In the police officer's dealings with my client, there were multiple breaches of the Police Powers and Responsibilities Act, the PPRA. When the police officers came to my client's house, they were out of uniform. They stormed into his garage, knocked him to the ground, and began yelling questions in his face. I would like to remind Your Honour, my client is a minor. The police officers then took my client in an unmarked police car and began questioning him. The police officers drove my client around the suburb he lived in, pointing to houses in a tone similar to this, saying, "Did you break into that house? How about that one there?" As you can imagine, Your Honour, my client, a minor, would have been very distressed in this scenario. Your Honour, my client was then taken to the police station for further questioning, and my client has been accused of 106 offences. Your Honour, I would like to address the sections of the PPRA that the police officers breached when dealing with my client. I would like to emphasise 3 main points today, Your Honour. The first main point is with regard to breaches that occurred because my client is a Torres Strait Islander. Secondly, breaches that occurred because my client is a minor. And thirdly, I will discuss the admissibility of the evidence consequent of these breaches. Your Honour, the PPRA was created as a result of the Fitzgerald inquiry. The purposes of the PPRA are outlined in Section 5. Section 5 states that one of the purposes of the Act is to ensure fairness to and to protect the rights of persons against whom police officers who exercise powers under this Act. Your Honour, within the first few minutes of dealing with my client, the police officers did not make apparent to my client numerous rights. For example, my client was not even made aware of his right to remain silent pursuant to Section 397 of the Act. Your Honour, my client is clearly identifiable in appearance as a Torres Strait Islander. Section 420 of the PPRA states that when questioning a Torres Strait Islander, unless the police officer is aware that the person has arranged for a lawyer to be present during questioning, the police officer must inform the person that a representative of a legal aid organisation will be notified that the person is in custody for the offence, and as soon as reasonably practicable, notify or attempt to notify a representative of the organisation. Your Honour, before questioning my client in the car, the police officer did not comply with these 2 requirements of the PPRA. Your Honour, my client is clearly identifiable as a minor in appearance, and the police officers did not comply with the relevant obligations when dealing with minors. In the process of questioning my client, the police officers breached Section 421 of the Act, which makes it a requirement that, if practicable, before questioning, the child should be allowed to speak to a support person chosen by the child in circumstances in which the conversation will not be overheard. The police officers took my client in the car and immediately started questioning him without adhering to this section. I do not see why it would have been any less practical to drive to the police station and adhere to this requirement before questioning my client. Consequently, the police officers also breached subsection 2b, where it is a requirement when questioning a juvenile that a support person is present. When driving in the car with my client, there were 2 police officers present during this questioning, however no support person was present. Your Honour, after the gruelling questioning my client endured in the car, he arrived 10 to 15 kilometres away from his home to a police station in the city. Pardon me. Might I remind you that at this stage, my client's parents had still not been notified of his arrest. Your Honour, my client then received more questioning here, where further breaches of the PPRA occurred. The police officers again breached Section 421 by not allowing my client to choose a support person to speak with. When my client was questioned at the station, a support person was present, in accordance with subsection B, However, it was not a person whom he had selected. Your Honour, the only piece of evidence against my client is his admissions of guilt, which were improperly obtained. Your Honour, no electric or written recordings of the questioning in the car trip were taken at the time, rather a written statement that was made up 3 months later. I ask the court to assess the aforementioned breaches with regard to the principles of fairness. Your Honour, it is essential that those who enforce the law do not break the law. This principle is outlined in Budding and Cross, the Island Discretion, and reflected in Section 130 of the Evidence Act. I ask the court to assess the admissibility of the evidence with the principle of fairness in mind when considering the aforementioned breaches. I ask the court to exercise its discretionary power and to consider excluding the only piece of evidence against my client pursuant to Section 130 of the Evidence Act. Thank you, Your Honour.